Thank you, Russell, and thank you everyone for the opportunity to speak here today. I'm very grateful to be able to talk about this particular problem of prosecuting fraud arising out of consumer transactions. This was the brief I was given in relation to today, talking about advanced fee scams, phishing, other instances of fraud and cybercrime directed at consumers and internet users. And then, just to finish off the day, I was going to talk about evidence procedure, submissions and sentence, defence tactics and specific defences, and I thought, well, that's pretty good. I've got a lot to talk about there, so it should be interesting. But then I had to ask myself, well, really, what sort of fraud are we talking about? When we talk about micro fraud or macro fraud, and to talk about that, I'd just distinguish the instance of crime where there's a huge dividend versus the instances of crime where there are many with small dividends, but they add up to a large number. And picking up from what Bruce is saying, it's not very attractive in terms of investigation to look at these multiple micro frauds. So David Wall is talking about this in the UK context in a 2010 paper, and he makes the point that they're conspicuous by their absence in the criminal justice system. And yes, that's been shown by my research looking into these matters for today, following up from what Bruce also said about his knowledge of cases of prosecution of fraud of this kind, and he had his one case to speak of. There are very few cases that you'll find reported about micro frauds. And when you do see them reported, they're often in relation to sentencing issues rather than any substantive legal issues to do with the fact of the micro fraud. So I just wanted to explore why these cases that we understand from all the evidence around us are increasing in terms of the exposure of people to the possibility of micro fraud and then their involvement as victims in micro frauds. Why is it that they don't turn up in the criminal justice system? Well, there's the problem of underreporting, particularly in this instance by banks or other financial institutions, whether they should have a responsibility to report matters that come to their attention. Because there's small impact, bulk victimisation with a low profile, they're not particularly attractive to law enforcement. That's complicated, of course, by the multi-jurisdictional spread, as has been clearly indicated by the talk so far today. And when you add on the disparity between jurisdictions, the job is all that more complex. And we're not just talking about the difference between Australia and the rest of the world. You can see the multiplicity of jurisdictional differences just within Australia as complicating the difficulties for law enforcement. And of course, the matter dear to the heart of the people who organised this conference, the importance of making sure that vulnerable people have sufficient knowledge to be self-protective. So, there's a question raised about how seriously this sort of fraud is treated, despite the increasing evidence of the scale of the problem and the amount of money involved. A problem of ensuring that we get reports to the police and that they might then be acted upon. There are difficulties because of the disjunctures in terms of the global nature of this offending, and it's just outside traditional policing. So these are issues that need to be confronted if you're going to be able to prosecute. So when I came to talk about prosecutions, I found inevitably that I had to talk about the problems of actually getting a case into court in the first place. The way you might see these offences is through not any computer aspect, no computer crime necessarily, but in terms of the fraud that's perpetuated through the use of computers. So we see an underrepresentation of computer-based offences. Now, a police response might be, and I got this from the need to have an agreement for the investigation for the case previously spoken about, that they might be too small as individual cases to warrant the spending of resources, which can be quite significant in terms of a cybercrime investigation. Some police, not all, may be inexperienced, and you've got the coding problem about cross jurisdictions. So if I was to talk then just about a few variants in terms of the crime types, and then try to, in doing that, gather them together in some way that we might make more sense of them, I'll just do that. But I need to talk a little bit about the changes to the law that are ahead for us in terms of the possibility, if the Cybercrime Amendment Act or Amendment Bill of 2011, if that actually survives and gets passed through the current Parliament, then we would have the first national law in terms of cyber offending. Whether that's actually useful in terms of micro-fraud remains to be seen, because, as I've indicated from the work from David Wall, you see a falling away of the computer aspect of the offence and a concentration on the fraud aspect in terms of seeing a charge that can be prosecuted. So we will have to wait and see what the effect of the Cybercrime Amendment will be, but more importantly, if it is passed, it'll affect sweeping changes to the laws in terms of evidence gathering for police, in terms of the requirements for the retention of information on ISPs and other data holders, and then on the international cooperation arrangements for mutual assistance. So if that actually gets through, then we'll see quite a different landscape in terms of a national structure for the law, and also perhaps, we should hope, an improved system for the sharing of evidential material. So just having said that, we'll look at some of the variants. The idea of arbitrage is that you might use the internet as a place where you can avoid local jurisdictional restraints on what you might access. So that applies to such things as pharmaceuticals, or there's a market in amphetamine type stimulants, those sort of things, and the constant change in their chemical nature, so as to try to avoid government restriction or criminalisation. And also gambling is a prime example of using the internet to avoid local jurisdictional constraints on what you might provide, because you're providing it in virtual reality. The internet service type frauds, so this is where you're buying a service or seeking a service and you're being defrauded in the arrangements for obtaining it. The investment frauds, so if we start lumping them together in this way, we can think of perhaps more targeted strategies in terms of how we deal with these particular micro frauds. The trading type scams, and often in those circumstances, the thing that might be most effectively targeted, of course, might be the agencies that provide the services for this form of exchange to go on, such as eBay, Craigslist and others. And then there's just the con artist, and we started with that today here with the Nigerian type scams. And of course then we had Bruce's presentation about the health type scams. So what we see is a high degree of variability, but at least some sort of streams in the nature of scams. But the complaint patterns are highly dynamic. They vary from year to year quite substantially, and the level at which loss is written off varies enormously. So this is compounding our problem about trying to get reporting and finding an effective way of dealing with this. So we have multiple victimisations, many different automated crimes, offenders within organisations assisting in the offending, crimes of the knowledgeable, and what David Wall refers to as democratised crime. So it's become so readily available, as seen from the video in terms of the UK experience and offenders there. So what's the prevalence of micro fraud? If we don't see it represented in cases where people are being prosecuted necessarily, so we don't see much evidence of it there. What other diagnostics can we use to try to get an impression of what the level of the problem might be? Now, in deference to the organisers of this event, I'm not stealing their thunder in terms of their own work in looking at Australian prevalence statistics. So I just wanted to draw your attention to these features from Wall's work, talking about 1 million cases with an average loss of $750 to $1,000. That was figures based on APAX, which is a clearinghouse type service for the United Kingdom for money transfers between banks and financial institutions. And now this is from the USA's IC3, so the Internet Crime Complaint Centre, their most recent published report from 2010, indicating, as you can see, non-delivery payments highest on the list, FBI-related scams and so forth. What's interesting to note from that is the difference between the percentage of complaints, which you can see in the left column, and the number of matters or percentage of matters that are actually referred then to a law enforcement agency. And what's drawn from the IC3 report is how important it is for them to have a financial loss of sufficient quantity to justify the referral of the matter to law enforcement. And so we see that money is involved in the non-delivery payment merchandise issues, identity theft, auction fraud and credit card fraud. In each of those, the percentage of cases referred is larger than the percentage of complaints. So bearing out that idea that the criminalisation follows where the monetary loss is greatest. In this map provided by the IC3, there's indication of countries involved in terms of complainants. So we're looking through an American lens at what the world looks like. And we've got 91.2% of the complainants to the IC3 website, so it's an American website set up by American law enforcement. The 91.2 are United States complainants. Australia figures in the list, but at 0.7%. But perhaps we might still consider, in terms of the fact that we get a world ranking of number 4 in terms of complainants, that's something of interest to us. When the IC3 then looks at where perpetrators come from, according to their data, we see that Australia goes back to 10th place with 0.5%. But a greater spread in terms of the perpetrators coming from outside of the United States. So in terms of complainants, it was about 91, and in terms of perpetrators, 65. Now, if we apply that American lens, we might think, oh, well, maybe a lot of this stuff comes from America. Maybe we thought actually it was all coming from Nigeria. Some of the difficulty with this might be the way in which transactions are routed through different countries. And so where it turns up, or the trail that you find for it, might actually be slightly misleading in terms of where the perpetrators really are. But this is what we can go on. Some of the complexity involved can be illustrated from this. This comes from a PhD of Macombi, who's actually produced a number of papers as part of the PhD process, and has written quite extensively about the influence of Russian organised crime in scam activity in Australia. He had quite privileged access to data that I'll just briefly touch on. But in this slide, he sets out the complexity of at least one of those operations involving criminal mastermind in the United States, but also Maxim Unger, Alex Mergi, Carlos Reggio, people who have strong links to Russian organised crime. And he goes through in his PhD, if you wanted to look at it, it's available online, in some detail with the Russian organised crime aspect of this offending. I just wanted to draw out the complexity of the arrangements between people involved in those organised criminal groups. So what do you prosecute? You might have some available offences directly from the use of a computer. In my opinion, though, we're not going to see many prosecutions for these sorts of offences where the ultimate objective is to deal with the fraud that comes from the person's activities. I've mentioned, indeed, though, too, the fact that the Commonwealth will be seeking to not cover the field. They're saying that the state and territory legislation that exists in terms of computer crime can be coextensive with the Commonwealth provisions, but the Commonwealth is saying, if the bill gets through, that there will be a national set of offences to do with computer crime. How that will affect the dynamic in terms of responsibilities for policing will be very interesting in terms of then the costs to the AFP of responding to what is now identified or will then be identified as a national crime issue. The derivative offences, these are the ones that we can see in the courts. So people who are being prosecuted for money laundering or identity crime, we can certainly see some of those and be able to talk a little bit about the issues that arise in those cases. Interestingly enough, though, not terribly many issues have been raised in the cases that I've been able to identify about substantive legal points, arguing whether the charge is properly made out or not. And that in itself might be an interesting aspect of how the law currently is. So the Crimes Amendment, Fraud, Identity and Forgery Offences Bill amended the Crimes Act here in New South Wales. Now I've just picked up the New South Wales example because I wanted to draw on the fact that there has actually been quite a bit of change through the Australian jurisdictions in terms of the way in which fraud is defined, beginning with the Commonwealth's changes and introduction of fraud offences into the Commonwealth Criminal Code. And the state offences have actually picked up the model that's provided by the Commonwealth offences. So this is in the area of fraud. And if you can see in terms of New South Wales, the gravamen of offending was substantially increased because the maximum penalty was doubled from 5 to 10 years. And the new identity crime provisions were added and the provisions for forgery were updated. So we can see a huge shift in legislative attention to fraud and related offences. We get on to some analysis, though, that's been provided by Alex Steele from UNSW about the whole McClock approach to the definition of fraud. And what Alex is pointing out is that in terms of the model criminal code and the way it talks about the difference between what are called physical elements of offences and mental elements of offences, that we have some potential for great conflict about these laws as they've been enacted. So that in the English law, fraud requires a subjective element of the person knowingly doing the defrauding. There's a line of Canadian cases ending up in the Supreme Court of Canada which says that that in their criminal law there's an objective test that's imposed in terms of fraud. And what Alex is pointing out is that in the Australian situation, following a High Court case of Peters, there's actually a blending because of the way in which the code talks about physical elements and fault elements. They've actually included in part of the physical element an aspect of knowledge or cognition of dishonesty. So it's actually quite a difficult and complicated position to be in, to have that mix up. And the point made by Steele is that Peters' case might come up for review at some point, and the High Court may actually rethink its analysis because of the complexities that may arise from this particular way of describing fraud. Because of this combination of subjective and objective standards. And the suggestion is that dishonest means is insufficiently inchoate to be used as the basis for setting up what's the actus reus, the physical act of the offence. That's a thing that we have to wait and see, but it's all part of the joy of federation, of course, that we will have the interesting exercise of working out what the implications of this Commonwealth law are, particularly now as it's been adopted as the model in a number of states. Another issue that was picked up in a case of Fumonia, I can't say it, Fumanoa, something like that, is the way in which 192E fraud in the New South Wales Crimes Act. They've got rid of the provision which talked about for himself or on behalf of another. So it only says obtains property belonging to another and is a person who. So it leaves out the possibility that you might do it on behalf of someone else. So it seems to me that that's either a very strange accident in the drafting office or quite a significant change to the way in which the law has been framed, and maybe that wasn't really thought about at the time. So I did want to point out, because I talked to my students about cybercrime, and we have portrayed this idea of the Nigerian, just like the fellow in the video, as this black African person who's the source of Nigerian scams. But Marinellis's case involved conspiracy to cheat and defraud. So the charges for Marinellis, who was running a Section 417 of the Nigerian Criminal Code type scam in league with Nigerians. So it was a sophisticated arrangement where he was providing the front of house persona, the credible Australian financial institution, he had a name for it that was registered as a business name, providing the comfort to those who were being fleeced. It involved obtaining money by deception, so as we see the BA offence could be used there, and fraudulent personation. So a combination of offences reflecting the points, I suppose, made by Bruce about how you might have to be a bit creative at times to capture the full criminality. In the sentencing for Marinellis, and Marinellis came from somewhere out near Dubbo, there were multiple frauds. The court said that called for accumulation. That wasn't actually done by the sentencing judge. So when they looked at the sentences, they said, well, it's just serious offending. One victim in Qatar had lost $450,000, and there was another person in Japan who fell victim to the scam for the sum of about $15,000. Adam J said actual loss is important. So they were talking about actual loss in that case. And 2 years, 6 months was the top sentence imposed, with a non-probation period of 1 year, 10 months and 15 days. Now the court said, because they're actually dealing with another charge, they were dealing with the other charge of attempt to pervert the course of justice, which was count 10 in the indictment. They dealt with that, and they said, had the DPP appealed on sentence, we probably would have increased the sentence for the frauds. But it wasn't part of the case, so that wasn't for the court to make that call. But they did note that it was a lenient outcome. So the indirect offences, we can think about the money mules connected to large-scale micro-fraud. McCombie's work also involved access to data from one of the major banks in Australia, and in 2007 the bank identified 806 money mules, according to McCombie. Now we haven't seen, I don't think, 866 prosecutions. So I think there's a real opportunity here to say, well, if there was reporting by the banks, if there was some national reporting agency, if there was coordinated effort, and if we made use of the new schema when it comes into effect of a national legal system for the computer fraud offences and for the style of fraud offences, then we might have more success in this area. The Joint Banking and Finance Task Force data, he also had access to. It's an incomplete data set that's got bits missing, but over the period 2004 to 2010, he was looking at the destination of transactions that were suspicious. 43% to Russia, 10% to the Ukraine, 9% to Nigeria. When he added in former Soviet states, the amount of money going to former Russia or former Russian states was of the order of about 60%. So I now just go to some cases. Tadros was a case from 2005. I'll just deal with these in the chronological order as how they were decided. This was a false identity fraud case with over $200,000 involved. There were errors by the sentencing judge about aggravating features. So as a result, 1 year was knocked off the head sentence and 1 year off the non-probation period. In Van Haltren's case, these were Bankruptcy Act offences, and it probably stuck in the craw of the judge that he was actually arrested as he was transiting through the International Arrival Lounge in Australia, and the customs persons noticed that there were lots and lots of identity documents in his baggage, and they started asking him questions about it. He was actually an undischarged bankrupt, and he was committing persistent identity crimes and travelling in and out of the country. $3.97 million said to be involved, and here we had a sentence of 6 years with 3 years, 9 months on the bottom. That wasn't changed on appeal. Brown and Tasmania, this is where we might think about how judicial officers think about these problems. We have a case today in the ACT of the Chief Justice dealing with somebody for a number of identity crimes, and he was, I think, sentenced, I read the report in the Canberra Times today, to periodic detention. But we're known to have a fairly lenient Supreme Court Chief Justice. But in this case of Brown and Tasmania, we have a similar, perhaps, view about trivialising the nature of the loss or the nature of the offending. A sentence of imprisonment for so many years for crimes of dishonesty is rare. So the judge in this case was prepared to reduce the head sentence by 3 years. 2 years. Yes? Done? Okay. In Stephen's case, multiple identity offences. This is a case that I wish to highlight because Spiegelman CJ quite deliberately made reference to the fact that the law was about to change and that there was a need to up the ante in terms of how these offences were dealt with. In this case, money laundering offences, the Commonwealth Super Scheme fraud, 6 years with 3 years, 7 months on the bottom. Sweeney and O'Brien, that was a co-worker stealing the identity of another person within the Darwin Magistrates Court. There were certain things made about the lack of evidence of effect on victim and no evidence of prevalence of the offence. So the judge used that to reduce the sentence. And Kroll's case, multiple false identities, and it points to the real difficulty, and this is probably the biggest bugbear for people who prosecute in this area perhaps, is the difference between prosecuting and getting a sentence for a Commonwealth offence at the same time as a state offence is involved. It becomes incredibly complicated and it's nearly always mucked up.
Thank you.